welcome back while Sarah Boone reads fan mail and adjusts to her newfound fame. Thank you for watching our Sarah Boone Rewind episodes. After being sentenced to life in prison, Sarah isn't having many good days lately. She has sweet revenge on her mind. Starting at the top of her list is Judge Cranick and her previous attorneys. In her 28-page letter, Sarah believes someone owes her big money. Sarah is demanding $15,000 for her services. Now that Brian has fled, she no longer has access to his money. She has found new victims. If everyone else has got paid, why can't she? After all, she earned it right. Let's take a look into the courtroom to see just how well Sarah did. Does she deserve $15,000? Never mind that pesky little bar exam. Who needs that anyway? Sarah excelled at everything. Surely this was a walk to the bar for her. Ironically, her first challenge is to get rid of the media and cameras. She would like privacy during her trial, and she doesn't like being recorded.
What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand-delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon. Mr. J. Yes, ma'am.
Forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or attendiously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out, to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive, and I was not instructed by anyone in the court that that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for, and that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told you on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically, on August 14th, 2024 at 1:30 p.m., a hearing will be held in Courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drug tribe, which contains the state digital evidence. The defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. It was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and that we would be addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you, absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State? Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am. All right. Your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my right. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
So was the judge being hard on Sarah? Was she in over her head? Do we feel bad for her? What do you think of her performance thus far? Just keep watching.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Mr. Banquets, I'll start with you. Tell me why you're moving to withdraw.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure that type of derogatory comments and expect to effectively represent someone, especially in a murder case.
How long the deadline might be
That
for
was
the
painful,
open-ended
but
items
there's
that I
more.
would be waiting for?
Chairman, I'll chip in with the legal piece of it. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates, and all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not. But from a legal concern, I can easily answer that today. And the answer again is, she's legally she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that
Not
question.
being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you
I'm not sure if she's asking me a question. I don't know.
which contain the state's digital evidence and digital transcripts of the depositions of Detectives Chelsea Kopsel and Scott Lowen, and he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
It did.
Okay, what was provided to you, if anything, at that meeting?
What he and I did?
What was provided to you? What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed. Have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than one.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seemed to work.
Okay, you did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay, all right. Okay.
It's on our to-do list.
Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client. You know, I know the court's in a difficult position, but at this point, we're at that impasse of if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
I told her from day one that her snotty attitude was inappropriate, and I tried very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she supposedly represented my life. Such as, why can't I have a bond? Why can't I have a download of my phone? Why can't I speak to my investigator? Why can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
I'm very leery about having a fair trial at this point. There's a handful of other...
What did you think of Sarah's Oscar-winning performance? Was it worth it? Should she receive attorney fees? Is she delusional, detached from reality? Or was she onto something? Was Sarah Boone out of her league? If you made it this far, I appreciate you. Know that. More videos coming all December. Breaking down the mind and trial of Sarah Boone, not malicious. Did she earn the $15,000? Comment below.
of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss.
dismiss this case.
Closed.
Drop it. She is not that type of person.
Good person.
She's a great person.
Angel.
I know she'd be an angel, but she's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
After the video evidence Sarah provided during this investigation, Sarah still could not process why detectives thought she was capable of such a thing. Let's watch her try to wiggle her way around the obvious.
Other than this, so initially, what was the cause of death?
She is still pending because she wants to hold the body for an additional day to see if more of those bruises turn into something bigger. And she's doing some other tests that she's got to do. So she's pending it for now.
So, and that couldn't have been because of him being in the suitcase?
Guilty conscience.
Or y'all are saying that